All right, members, we've got a quorum already, and so may I now call the meeting to order. So let's invite the administration in, and we'll continue with the scrutiny of the Product Eco-Responsibility Amendment Bill 2013. This is the 9th meeting of the Bills Committee. All right, I think we can continue. May I refer members to paper? The minutes of the meeting held on the 22nd of October, that's paper 521. The Secretariat hasn't received any proposals or amendments. So members, do you have any amendments to propose in relation to the minutes? Can we confirm the minutes, please? Thank you very much. Right. So we'll continue to discuss a few legal points and policy issues with the administration. We've got paper CB 1545 1314 bracket 02. And this is an information paper in response to the points made by members and our legal advisor. And I think we'll have to spend some time dealing with this paper. And of course, if we still have time, then we can discuss the CSAs proposed by the administration, right, Mr. Lai? Because last time you were at the meeting from 2:30 to 4:30, and then at another meeting from 4:30 to 6:30. So we have Mr. Andrew Lai, Deputy Director of Environmental Protection, Mr. Samson Lai, Assistant Director of Environmental Protection, Ms. Selina Lau, Senior Government Counsel, and finally Ms. Cheng Ching-man, Senior Administrative Officer, EPD. So can someone take us through paper CB 1545/1314 bracket 02, please? Thank you, Chairman. So this paper contains our responses to 4 points made last time. The first 2 points have to do with the legal basis. Now, we have no intention to implement a dual system. In other words, we don't intend to impose different treatments for operations of different scale. So our proposal is to implement the measures across the board. So some members are of the view that there should be a dual system. And so we have provided our preliminary observations for members' reference with regard to the legal aspect and the policy aspect. And Ms. Lau from the DOJ will supplement later on the legal perspective. Now we understand that Mr. Wu feels that there is a reporting system under phase 1. Now retailers have to provide reports to the administration on a quarterly basis with regard to the amount of levy collected and the number of plastic bags issued. And I think Mr. Wu is now concerned about the reporting of the number of bags in phase 2. Now, in our view, if under phase 2 the PSB levy is expanded to cover the entire retail sector, then the number of outlets will be increased from the present 3,000 odd to about 100,000. Second, even if we retain this reporting system, now let's put aside the legal arguments for the time being. Now, we have to look at the actual situation. At the moment, we have about 40 groups, about 3,000 retail outlets providing reports to the administration on a quarterly basis. And in fact, in 2012, 450 million plastic bags were consumed, and the amount they issued accounted for less than 3%. So if you try to imagine the situation of consumption of plastic bags territory-wide, you know what we're trying to say. But of course, I understand Mr. Wu's concern. You want to have a mechanism whereby we can monitor the effectiveness of extending the PSB levy to all retail outlets. Now, at the moment, we are of the view that we are using 90% PSB less. And in fact, every year we do have surveys concerning plastic bags disposed of at landfills, and so I think we can conduct such a survey, and that would be very informative. And Mr. Wong Ting Kwong is of the view that in fact we should impose a levy on the importers of PSBs. Yes, if we really want to monitor the situation, I think that figure can serve as a useful indicator. And so, if we want to have a reporting mechanism whereby we can monitor the consumption of plastic bags in Hong Kong, then we're of the view that there are alternative ways, alternative mechanisms, which will be more effective in our view. And last time, members asked whether there should be a grace period during which only warnings would be issued. Now, I think we are in a difficult position. Now, we will be the enforcement department, and we will have to act in accordance with the law. So at the moment under the bill, there is no provision for a grace period, and so law enforcement officers have to take enforcement action, or will have to take enforcement action if they discover irregularities. But then we do understand that this new PSB levy will have an impact on society at large. We understand that public education is very important. And that was why last time we told members that after the passage of the bill, we would need about 12 months for publicity and public education. And we will need to carry out publicity in a focused manner in different trades so that the different trades know how they will be affected. And then D. Some members were of the view that the fixed penalty level of 2,000 was excessive. Now, I want to say that we made reference to the 6 convictions under the current phase, And so we have proposed $2,000 as the fixed penalty level. Ms. Lau from the DOJ can elaborate on the legal arguments. Now, in fact, there are a few parts in the paper. There are some parts on the policy aspects, and Mr. Lai has already taken us through those parts. And then there are parts on the legal arguments. So Mr. Lai has explained why the administration is reluctant to put in place a dual system. And then perhaps I can now invite the DOJ to take us through the parts on the legal issues. Ms. Lau. In fact, we've sought the advice of our human rights experts. Now, we need to consider the right to equality and non-discrimination protected by Article 22 of the Bill of Rights Ordinance and Article 25 of the Basic Law. And in fact, our arguments are contained in paragraph 3 and 6. And in fact, these arguments are rather technical in nature. Now, we in the gist are of the view that there are no clear definitions in the UK, in Europe, concerning the definition of other status. In fact, they've got some new interpretations, and so we want to show members these new trends. And concerning the cases, they are rather technical in nature. So do you want me to go through those cases? Now I hope that you can help members and the public to understand these cases. So I hope that you will not say that you will not go through these cases because they are too technical. I'm willing to explain to members. Thank you. We're willing to listen. Last time, the legal advisor said that concerning how Hong Kong courts interpreted Article 22 of the Bill of Rights Ordinance, in other words, equality and non-discrimination, one important consideration was other status. And it was said that the judge was of the view that other status meant personal characteristics. So in this case, we are talking about big retailers and small retailers, but these are not personal characteristics. And so it seems that we really can't apply that particular case to this present case.
So on this point, we had looked at some UK rulings and European court rulings. So what are the descriptions of other status? So as in paragraph 6, it says that since the Court of First Instance's decision in Financial Service and Systems Limited, the UK courts and European Court of Human Rights have clarified the ground of other status under Article 14 of the ECHR is not limited to differential treatment. We do have an annex, the annex listing a summary of the court cases that I quoted, and we have highlighted in bold that the issue of the protection conferred by that article is not limited to different treatment based on characteristics which are personal in the sense that they are innate or inherent. So our conclusion is that there are different descriptions on this point, and there's no conclusion yet. So, legal advisor, would you have any opinion? to share with us. Well, I have to thank DOJ colleagues. They have told us that it seems that there are two stances regarding interpreting other status. There isn't an accurate ruling in Hong Kong at this point. It's just that there are two sets of views on other status. Okay. I see Mr. Fong Gong wishes to speak. Thank you, Chairman. I'm not familiar with these legal concepts. I just want to put it simply. The dual track system, I support the government. That is, I don't support a dual track system. In phase one, we targeted 3,000 odd supermarkets, and the government trumpeted its success. So the 4.5 billion plastic bags is exaggerated. But of course now, you now say that the reduction is more than 90%. But I think you have exaggerated. And now you want to extend it to other retail outlets. Well, I don't necessarily object, but it has to be fair. And Hong Kong has a fair, competitive business environment. You can't say because I'm a big retailer and I have to comply, but then you ignore the little retailers. I think that is not appropriate. I think regardless of whether you're a large or small retailer, it should be applied across the board. Now, you don't need to remit the levy. You don't need to audit. It's good for the little retailers. If the small retailers have to do that, it would add extra burden. They don't have the facilities, the staff to do that. But I think a large company, they've been doing this. They have social responsibility. They have corporate governance. So even if they don't remit the levy, they continue to charge the levy, the 50 cents. They have the computer, the staff. They know the figures at the end of the year, and they can do environment work voluntarily. So I would encourage the large companies to do so. They should collect the levy for environmental donations. For medium retailers, I suggest there should be a fund. So if they used a plastic bag, you can deposit 50 cents. If you ask people to audit, they can't do that. All they can do is just have a piggy bank, and they can use that money for environmental projects. So I think that can be implemented across the board. It won't add burden. We also have street hawkers, we have social enterprises. They can't handle this extra workload. They'd rather be charged, and if you fine them 2,000, it would too heavy a burden. I think 2,000 is quite exorbitant, especially for SMEs. If they are caught in a sting operation and fined 2,000, it's not necessary. I don't think a lot of people would want to abuse this loophole. They're not saving a lot of money. But as Mr. Lai said, if we want to extend the coverage from 3,000 to 100,000 retail outlets, that's a large amount of savings. So the government should exempt the hawkers and small retailers. In our visit to South Korea, hawkers in South Korea, they are exempted. So I hope the government can make reference to overseas jurisdictions. That's my suggestion. I would invite Mr. Fong and other legislators to discuss the penalty level, the $2,000. It seems that the government has set its mind on 2,000, unless we have colleagues who wish to seek a change. Otherwise, if there's no counter proposal, I'm worried that the discussion would stop here. The second problem, I'd like colleagues to take note that if people object to the dual track system, and we heard that there's a call for exemptions to small retailers. So do we have a separate dual track system? Well, Chairman, phase 1 penalty was 2,000. Is that correct? Phase 1, for large retailers, the penalty, there isn't a fixed penalty arrangement. The judge has to rule. But in the past 6-7 cases, the average was $2,000. This is just successfully convicted cases. But if we extend to all retailers in phase 2, we are looking at a convenient measure, a fixed penalty, rather than going to the courts. That can alleviate the court pressure. Chairman, I'd like to add that phase 1, the target was large enterprises. So 2,000, they can entertain that. But now you are expanding to SMEs as well. So a penalty for large enterprises applied to SMEs, I think 2,000 is very high. I understand Mr. Fong's view. His analysis is correct. We are looking at penalties for large enterprises and applying it to the extended phase. Well, but if it's a fixed penalty, we want some deterrent effect. So the plastic bag levy can be avoided. They just need to collect 50 cents from the person wanting the plastic bag. So they are only fined 2,000 if they are caught providing a plastic bag without charge. Well, if you were to visit markets, wet markets, during the holiday season, they are so busy, it's hard for them to collect 50 cents. Next, Mr. Loikok. Regarding the dual-track system, I had expressed my non-support because of the efficacy in phase 1. You want to extend it to all retailers in Hong Kong. From the feasibility perspective, if we have to comply with phase 1 to remit, that's not practical. But colleagues have also mentioned that if large enterprises can do it, why you don't continue the remittance? Well, as in the explanation on human rights just now, there's an argument for both sides. So the document moves on to the justification test, and I think that is acceptable. Regarding differential treatment and whether it achieves our legitimate aim, I think that is a good explanation. So I maintain my stance of not accepting the dual track system. Regarding exemptions, it should not be based on size of the retailer, but rather exemption on plastic bag usage. For example, for frozen foods, I think that is reasonable. But in practice, I feel I don't see large or small retailers would want to breach the law. It's not reasonable. If there's a law there, I'll have to charge 50 cents. They don't need to give it out free and force you to use one. So if you look at the food status allows for exemption, I think it would be chaotic initially. It might even lead to disputes between the retailer and customers. The seller might feel it's not justified. So it's not just a matter of levy or not. We need publicity and education. We've spent a lot of time on these exemptions. We've had discussions on legal terms. So we need to avoid disputes between sellers and customers.
And so, Chairman, my worry is not the penalty and how enforcement action is to be taken, but rather there may be a lot of disputes on a daily basis. Mr. Wuchiwai and then Mr. Ho. Thank you. Now, Chairman, members have been talking about the dual system. Yes, we understand that, in fact, we're not talking about the levy collected having to be submitted to the government. In fact, we are talking about whether the larger chain stores can continue to provide reports to the administration. This is in fact an existing practice. So my amendment has nothing to do with the levy. My amendment is only related to the keeping of records. Now, on this one, I think I can see eye to eye with Mr. Vincent Fair, and that is we are not asking the small and medium-sized retailers or operators to provide reports to the administration. And then, of course, I do understand that the issue of differential treatment needs to be addressed. Now, according to our legal advisor, in fact, there are two different sets of concepts. So it is not that there is a very clear or rigid definition. Now, in fact, under phase 1, in fact, there is an element of differential treatment. So, is it that if there can't be differential treatment, then no phasing arrangements can be allowed at all? So I hope that the Deputy Director can give an answer to this one. And then I have in mind 3 chain stores. If the administration doesn't like this criterion, then we can adopt the criterion adopted by the administration in phase 1. Okay, 5 chain stores. I've proposed 3 chain stores because I want to cover more chains. Now, in fact, I really can't verify whether a chain which has 3 branches will definitely have a computer system. But then I'm willing to go by the criterion in phase 1. For example, the premises being about 2,000 square feet in area, and so on and so forth. Now, I want to explain what I want to achieve. Now, I'm not trying to stir up any objection to expanding the PSB levy scheme. Now, in the past 2 to 3 years, we had good achievements, and I hope that this improvement can be sort of strengthened. So that's my concern, and that is I hope that we can still have these records so that we can further strengthen and consult, so that we will have the data records to show that the public's behavior or improved behavior can be strengthened and consolidated. Right, Deputy Director? In fact, the objective of this bill is simple. We hope to expand the PSB levy scheme to all retail outlets, and we hope that through imposing a levy, fewer plastic bags can be used. We have no intention to deal a blow to SMEs, and we have no intention to increase the Treasury's revenue through expanding the levy scheme. So, there are some exemption arrangements because of the nature of the food items, and otherwise consumers need to pay 50 cents for the plastic bag, and the retailer, of course, has to collect the 50 cents. If consumers don't want to pay the 50 cents, they should bring their own bags. And so we hope that we can have a mechanism which will apply across the board. And then there will be undercover operations. Our colleagues will from time to time go to supermarkets, markets, to see whether there are retailers who do not charge consumers for the PSBs. And if they are caught and prosecuted and convicted, they will have to pay a fine. Yes, I agree with Mr. Vincent Fang. It's important that in Hong Kong we have a level playing field, we have a business-friendly environment, and we do bear in mind these principles when we implement environmental protection measures. Mr. Wu is saying that under phase 1, these retailers are already keeping records, and so as their record-keeping systems are already there, they should be asked to continue to provide records for the administration's reference. Now, I have two considerations from the operational point of view. I'm not talking about the legal arguments here. Mr. Wu, you are right. Concerning the 40 large groups, the 3,000 retail outlets, yes, they do have computer systems to capture such data. Such computer systems have already been put in place. But then, if they provide data to EPD on a quarterly basis, then, as this is a requirement under the law, the EPD has to check the data. And if the figures fluctuate, for example, then we will need to carry out investigation. And the reporting system is not as simple as members may think. I asked my colleagues whether it was as simple as getting about 40 returns every quarter. But I understand from my colleagues that these groups need to register with the EPD. Say, if a supermarket chain has opened 3 more branches, then it has to register with the EPD. And according to my colleagues, every year we need to deal with about we have 200 items of information with regard to opening of new supermarkets, new branches, or relocation of the branches. So do you want EPD resources to be used on publicity and public education or on the vetting of the records? Now, and as I've said, every year we in 2012 we used many plastic bags, but less than 3% were issued by the large retail groups. And also, if you and I think we should give these large retail groups more liberty, let them decide what they want to do in terms of public education. And also, now, if the law requires that records be submitted to the EPD, our colleagues in the EPD have to ensure the accuracy of the figures. Now, say for example, in the last quarter, a retail group said that 100,000 plastic bags were issued, but this quarter 10,000. And I'm sure members would expect us to carry out a thorough investigation to verify the figures. So is this the best way to use EPD resources, including our manpower resources? I'm not saying that our colleagues do not want to work hard, but then I think we need to make sure that human resources are used in the most cost-effective manner. Now, I'm not trying to say anything on behalf of the big groups. All right, phase 1, 3,000 retail outlets. Now, this phase was implemented over 4 years ago. Our colleagues carry out undercover operations, over 100 every month, and we also asked consultants to carry out undercover operations. So In fact, we've carried out over 10,000 undercover operations. And how many irregularities, cases of irregularities, have we detected? 7. So I want to say that, in fact, these big retail groups have already done a lot to educate their frontline staff. And is it really worthwhile to spend so much EPD resources to keep track of the number of branches of these retail chains, whether these branches have been relocated, and how many bags have been issued? This is is this the best way to use our resources? And under phase 2, over 100,000 retail outlets will be covered, and that's going to be a very big challenge. So is it really better to use our resources to educate the retail or the retailers so that they know how to comply with the law? Mr. Wu? Now, if you had said this earlier, I might have come to a different conclusion or view. So, in fact, I have to apologize because I don't really understand the workload that my amendment may generate. What I want is a tool operated by organizations which have the means and the resources. Perhaps I need to think about the matter again. So I have to bear in mind the implications of having a mechanism provided for in the law. But what I want is that people's habit can be consolidated with the assistance of these large retail groups. And of course, I will also look at the legal arguments again. But now I understand that under phase 2, everyone will be covered. But then the records will only be kept on a voluntary basis, and so ultimately we may have to rely on counting the number of plastic bags at landfills to assess the effectiveness of phase 2, right?
I do not wish to see that under this regime we don't see major improvements on the 4.5 billion plastic bags. The 3,000 outlets were able to reduce 90% of plastic bag usage. So if we extend it, do we have any targets? So if everybody thinks the habits are reverting, we have to rely on sting operations. If we have to tighten it, then I feel we are actually taking a step back. So can we small steps, Ms. Sid Ho. I know Mr. Lai is busy. I've seen Mr. Lai in 4 meetings, so I support the posts, the D2 posts. I'd like you to create the post and so that you can. He said he just confirmed that he's got enough staff to count plastic bags. I will support you in creating the posts so that we have more policies and staff to implement them. So that the goals are clear. You don't require remittance, then will old habits resurface? That has been our only concern. If you say you can't rely on sting operations, well, Mr. Lai said targeting at source. You seem more agreeable to this idea now. Mr. Wang Dingong has been consistent in his approach. He says if you want to know how many plastic bags we're using in Hong Kong, you should look at the source. Have they increased? But then at that time you had no response, and now we have to conduct CSAs. It's very hard, Chairman. And I have to thank Mr. Wu Jiwai for his efforts. Mr. Lai, you're saying you are now more flexible in examining at source. So how will you examine the source? We just want more monitoring. If you can have administrative measures, we don't need to amend the law. Third is a legal question. Since our 6th meeting, they have talked about human rights and how it was unconstitutional. You referred to the 2012 panel and documents dating back. But the DOJ colleagues said the DOJ feels there's no conclusion now. There are two views. Initially, we urge you not to refer to human rights and discrimination. Now, our legal advisor has drafted a document. It was tabled in the 6th meeting, saying that human rights should not be applied. There should be a justification test. Now, our consultant was very clear. The consultant said that these standards are not personal characteristics of retailers, and there should be some clarification. And now the clarification is that there are different views. But I would like to have it on record that will you withdraw your reference to human rights and how it's unconstitutional and so on? It's because 10 years hence, a first-year law student, will see that the plastic bag levy was unconstitutional. So could we have it on record? And the DOJ now says that there are two views, and I'm not totally satisfied. There should in fact only be one view. That is, retailers do not have personal characteristics, and we should not judge them by the human rights discrimination. And I'll also ask the DOJ to withdraw your previous statements. Thank you, Sid Ho. I'm not a legal expert, so the government or the DOJ, we have just provided points for discussion. We don't have a definitive CSA, and we cannot make a general response. So we just say if there is a certain line of thinking, there are certain items that you need to be aware of. So we just want to provide some reference. Ms. Sidho mentioned 2 issues. Thank you for your support of creating more posts, but I can tell you that when we extend the plastic bag levy, we don't need to recruit more staff. We still have the same 12 people, so we have to examine their workload. Second, Ms. Ho asked, Mr. Wong Ding Gong suggested, if we want to be effective, we should target the importers, the source. If I were to just charge a levy, then Mr. Wong Ding Gong's approach is the best. But the levy is not to collect money. We want to change consumer behavior through the levy. And we see from phase 1 that if the retailers have to pay 50 cents for a plastic bag, that has the biggest impact. That's why we insist on levy at the retail outlet. And Mr. Wong Ding Gong's suggestion, we feel it can satisfy Mr. Wu Jiwai's concern that if we are to monitor the efficacy of phase 2, so aside from counting landfill plastic bags, we can look at whether there are any drops in plastic bag imports. So I will use the import of plastic bags as a KPI. I made it clear I wasn't talking about levy. We just want to monitor the usage. Will it increase, decrease? That is the focus. So if they collect 50 cents to cover costs, or they charge more to earn a profit, that's not a problem. We're not concerned about the retailers earning extra 10 to 12 million. We're just concerned that in the next phase of the scheme, will old habits resurface? So saying it's convenient to collect figures at source rather than 100,000 retail outlets, I would ask the administration that when the law is endorsed, could you meet with suppliers every 6 months and tell us what the figures are? Our request is very simple. I'd like to remind colleagues that we have discussed this, but before you attended this meeting, Mr. Lai, you had said it was not feasible. The government doesn't have statistics. But to facilitate this discussion, you need to consider how these things can be done. So if the government has some new thinking, or there are new measures to assuage us that after endorsement of this law we can monitor the use of have there been less import of plastic bags besides counting plastic bags at landfills. We'd like to know if the government has a new perspective. I just want to remind everybody, the government said it was not feasible. Well, perhaps the situation has changed now, so how would you proceed? I've taken up this less than a month. I understand what my colleague had said. according to Census and Statistics, import of plastic bag, they have a definition, but that is not necessarily that's not necessarily equivalent to the number of plastic bags we use at retail outlets. So, aside from counting plastic bags at landfills, how do we find relevant indicators to understand the problem? I can definitely tell you that each statistic has its limitations. So we need to see one indicator might not indicate the usage of plastic bags in Hong Kong per year, but it might be able to indicate any changes in the trends. Well, I'd like to urge Mr. Lai to tell us how should we monitor plastic bag usage. I'm aware this amendment is very difficult. Because there are a lot of retail outlets, and it depends on how the methodology used to monitor the usage, and that would affect whether I support Mr. Wu Jiwai. If you can provide acceptable administrative measures to monitor plastic bag usage, that would impact on whether I endorse Mr. Wu Jiwai's proposal. 在外区 Ultimately, we want to charge a levy to reduce plastic bag usage. We have 40 large enterprises, so this is indicative. I feel the bill, the sooner you endorse it, the better. Of course, we see other jurisdictions. It is a levy is effective. So if you charge a levy, then everybody will think twice before using a plastic bag. So I think this should take precedence. You talked about dual track system. Even though I mentioned this very early, it's difficult to backtrack, even including remittance, and because if you look at the direction, we can find a balance, and I would like it to be implemented as soon as possible to reduce plastic bag usage.
So under this principle, I will not support a dual system because I hope that the bill can be passed as soon as possible. Chairman. Yes, I understand that we need to assess the effectiveness of a piece of legislation. I think we and we would accept that concerning the statistics, it's not as simple as 1 + 1 = 2, but you can't say that we won't have any statistics. And I hope that we'll have statistics showing us the effectiveness or otherwise of the legislation. Yes, we understand that at the moment, because of the 50-cent levy, many people have decided to bring their own bags. And I think this bill should be passed as soon as possible. Phase 2 should be launched as soon as possible. And then the $2,000. I understand that this is based on the fine levels in the convictions. I have no strong views about the level, but then at the moment, these big retail groups have to submit the levy to the government. But this is no longer going to be the case. Now, for a small shop, if it issues a lot of plastic bags, then 50 cents per bag can be a source of income. So concerning the level of fine, $2,000, whether that's deterrent enough. Now, of course, if you think $2,000 is deterrent enough for the big retailers, of course, it can serve a deterrent effect on the small retailers. But then what about repeated offenses? Will repeated offenders have to go to court? I agree with Mr. Loy Kwok concerning, yes, there can be exemptions based on the types of food, state of the food, but then these definitions and criteria must be clear so that there won't be disputes. Now, concerning in the frozen state, right? Ice cream, that's clear. But what about fruit that has been cut? So is it that if the fruit that has been cut is put in a fridge, then a plastic bag can be issued? But if it's not put in a plastic bag, but if not, it's not put in a fridge, then no plastic bags should be issued? And so I just want to say that that's my position. Thank you. Mr. Lai? Yes, I thank Mr. Chair for his questions. Now, in fact, we do agree with Mr. Chair. If we can pass the bill as soon as possible, if we can launch phase 2 as soon as possible, we'll be able to reduce the number of plastic bags used. The earlier the passage of the bill, the earlier the effects. At the moment, these big retailers have to submit the levy collected to the government, and we have to make sure that the amount of revenue collected is correct. So we have to do a lot of verification work. But then if we discover that the frontline staff of the retail groups issue plastic bags without collecting 50 cents, that will of course attract prosecution action. So we check the records. Unless the retail group gets involved in systemic fraud, generally the group will not want to commit an offense because of the 50 cents. So we mainly look at the frontline staff, whether they comply with the law. Then repeated offenses, I think our assistant director can supplement. Chairman, the law enforcement officer will decide whether a fixed penalty should be imposed. And of course, the retailer can refuse to accept the fixed penalty ticket. The retailer may prefer to go to court. So it really depends on the circumstances of the case. And concerning repeated offenses, now, at the moment, the maximum for a first-time offender, the maximum fine is $100,000. But then for subsequent offences, the maximum penalty or maximum fine can reach $200,000. But then under phase 1, we haven't got any retailer which has repeatedly committed offences. And so we do expect that under phase 2, repeated offences will attract heavier fines. Now, Chairman, I think we do need some measures to assess the effectiveness of the legislation. For example, counting the number of plastic bags at landfills and so on and so forth. So we do have to have a basis to assess the effectiveness of the legislation. And then secondly, concerning the level of fine, yes, I understand that if the case goes to court, the court will decide on the amount of fine. But I think the law enforcement officers need to have certain criteria to go by in deciding whether to issue a fixed penalty ticket or to bring the matter to court. So I wish to follow up on this matter. So the law enforcement officer may issue a fixed penalty ticket, may decide to do so, but then does he know that in fact 2 days ago another law enforcement officer issued a fixed penalty ticket, and it's $2,000 excessive? And I think there is room to adjust this amount downwards, because under phase 1 there are these 40 retail groups. They have to submit the levy to the government, but under phase 2 the retailers can keep the amount or they keep the levy, and it's only 50 cents per bag, and so I think maybe $1,000 should be adequate for the small retailers. Yes, Chairman. In fact, we are open to members' suggestions concerning the level of fine. There will be guidelines for our frontline staff. So if it's a simple, straightforward case, then a fixed penalty ticket will be issued. But if it's a complicated case, that will not be dealt with by a fixed penalty. Now, I got the impression that in fact it might not be $2,000. It could be the $0. But in fact, I think the understanding should be that the retailer can choose to accept the ticket or go to court. But then the fine will be $2,000. Right, Mr. Vincent Fang, and then Mr. Wu Chi-Wai. Yes, Chairman. I want to say something about the administration's CSAs. 2A. I think the wording is rather vague. What do you have in mind? Now let me show you this. Airtight. Do you regard this as airtight packaging? So do you regard this as airtight packaging? These are candies. And then vacuum, and then B is clear. In a cold or frozen state, right? Including ice cream, right? Mr. Vincent Fang, you just put this in the fridge. Then what about fruit put in the fridge? Now in supermarkets, we see fruit cut into pieces, apples, strawberries, put in paper trays or plastic trays. In fact, I did ask the permanent secretary the question. So is this airtight? But what if there are some holes in the plastic tray? Now this is to let air in and to allow the water or the juice to come out. And then last time it was said that if there were holes in the plastic tray, then there would be an exemption. Alright, frozen goods exempted. But what about these? Because you can buy such candies very easily at hawker stores, right? People just buy some, put them in a plastic bag, and so do people have to pay 50 cents for this plastic bag? Because you can't carry all these candies in your hands. You need a plastic bag. I just want to say that these are just day-to-day examples. And you can easily buy these at hawker stores. We see such packaging for candies, for biscuits. And then A. Plastic shopping bags. And then B. Plastic bags. So what types of bags do you have in mind? Why is it that you are using different terms?
Regarding disposable material, in clause by clause, we had discussed this. It could be in your example, we also include vacuum packaged goods. So that has been reflected. But packaging comes in different varieties. The disposable packaging indicates that the food hygiene has been handled. Regarding frozen goods, that is a separate issue. Even for disposable packaging, if it's frozen goods, because of the frozen nature, it can receive an exemption. Because the view is that there is condensation from frozen goods, and the plastic bag levy can therefore be exempted. Of course, we can provide some guidelines, and because of this, we hope that there can be some time for publicity and promotion. So we will provide some guidelines. In the candy discussion, we see that the plastic bags of those types, they can be exempted. We also heard views that some retailers, they would rather use substitutes, so we would see what is most appropriate. Could you indicate where the exemptions are? Can I repeat this is exempted? I'm concerned where the exemption is. Annex 2.1, we've included some bags. If they are part of the product, it should not be considered as a plastic bag. They can be exempted from 50-cent levy. One category is a specifically designed bag for that product. Chairman, according to his explanation, I can see it. This is part of the food. It's individual wrap. This is part of the food. But the question is, I'm purchasing a lot of individually wrapped candies, and I need a separate plastic bag to contain that, to purchase this. So this, does that attract a 50-cent levy? Your explanation, I understand it to be this, the disposable wrapping. Could you explain it again? Mr. Wang Dingong has highlighted two bags. One is the candy wrapper. That has been sealed. My explanation is that that is not a shopping bag. We see there's another bag that contains these individual candies. So my explanation is this is a snack retailer who has provided these bags to contain the snacks. So we have provisions that are not plastic bags that do not need to charge a levy. I don't understand, but do you think if you think it's clear, then I have nothing to add. Chairman, Mr. Lai, I had mentioned this on the last occasion. I referred to clothing, a plastic bag for a men's shirt. So that plastic bag is not included. So this, it's equivalent to the candy wrapper. That's very clear. It's not levied. Mr. Lai, I don't understand your explanation. So if I purchase these candies, so this plastic bag, do I need to pay 50 cents? You already answered you no. So you're concerned that there are different interpretations in law enforcement. So you can see, Chairman, so the candy retailer has designed this bag for these products. So we want to encourage consumers to bring their own bags. So these two bags are not substitutes for each other. So under our policy intention, so the conclusion is that this bag does not need to levy the 50 cent. Mr. Wu Jiwai. Well, I'm getting more and more confused. On the last occasion, let's say Yao Ji Lang Ban, they have a Ziploc bag at 100 grams, 200 grams. So, using the same reasoning, if I purchase 5 shirts, the t-shirt bag, the shirt bag is not included, but the 5 shirts, I purchased 5 shirts, and I asked for a plastic bag to hold the 5 shirts. So that is a plastic bag designed for containing the shirts. I'm not sure if I have misunderstood, so I'd like to clarify that. And the second question is about my amendment. I want to ask, since we're about to take this route, have we discussed with large retail outlets? They have a transaction process, so in their retail system, will they include the plastic bag transaction as part of their transactions? So large retailers, their accounting system is very detailed. Have you contacted them? If they're willing to include the plastic bag in their transaction, I want to know if you asked them this question. The candy wrapper, it's the same as where the candies are sold by pound. In the shirt example, we will consider, let's say when you purchase a suit, you are given a bag to hold the suit. That might fall into this category, but the shopping bag is not a product designed for a specific product. That is our consideration. Our discussions with retailers have been ongoing, and in the past we had explained to the Bills Committee that existing retailers, their stance is to maintain the existing administrative system. Some green groups have contacted these retailers and explored whether the levy can be donated to charity, including environmental use. Our understanding is that the response has been positive, and in newspaper interviews, some retailers have already expressed this view. So it depends on when the law is endorsed and the contents of the law. So that's one reason why we want to speed up the process such that these views can be implemented. I just want to clarify Hong Kong produce a typical bag. So let's say if I visit a wet market, we have these individually wrapped candies, and they are sold by bag, by pound, on a weight basis. So then Hong Kong's plastic bag is not one that is exempted. If Mr. Fong Gong's bag is exempted, then the shirt bags are also exempted. It's not the suit bag that you described. It was clear in our last discussion when we talked about Yao Ji Lamban, the snack retailer that has bags that contain merchandise by pound. The zip bag that holds candy does not attract a levy. I want to clarify that. Regarding Fong Gong's two examples, I already made an expansion. The first was his own shirt. Some stores, when they sell shirts, there's no packaging, but some have a plastic bag. I had explained to him that that bag is designed to hold the shirt. Now, if a retailer bundles 5 or 6 t-shirts and holds it in one bag, that is not the current operation practice. So that leads to the second point. We have retailers selling merchandise by weight. So after enacting law, if they do that, they might not be exempted. And we foresee that some retailers will need to adapt their practice accordingly to comply with the law. And I understand that the retail industry wishes to comply, so we don't see producing special bags to avoid this or to comply with the law. If you do not refer to Mr. Fong Gong's bag not needing money, but if you say his bag does not need money, then it indicates some in 4A, the description says that the bag is specifically designed for holding the product. Specifically designed, that's quite important. You need to explain whether the 50 cents is levied. It depends on the interpretation of specifically designed. So, Mr. Fong Gong, it depends on how he explains the situation. We could understand is that for these candies, it is specifically a plastic bag was specifically designed to hold the individual candies. But Mr. Wu Jiwai says, if a generic plastic bag is used to hold the shirts, then it's not specifically designed.
So it really depends on the situation, and maybe with the passage of the spill, the modus operandi of the hawkers may change. For example, they may work out certain arrangements so that they will be able to satisfy the definition of the bag designed for the goods. But then Now, if undercover operations are carried out, then is it that the frontline staff do have a clear understanding of 4A? Because there are really different ways to do business. So we hope that when enforcement action is taken, there will be fewer disputes, and there will be less inconvenience caused to the operators. Specially designed. No, I had some hesitation because the bag shown by Mr. Vincent Fan was regarded as a bag of special design. So, was that a case for exemption? But then, what about the bag containing the shirt that I bought? Yes, Chairman, we understand the concern because we're talking about phase 2, and we're not merely covering the big retail chains, but all retailers, including hawkers. And of course, we will not or we'll try to make the legislation as clear as possible, and there will not be a scenario where we tell hawkers that we don't know and we have to go back and check the books. Now you can do as much research as you want to, because we do have ample time. But of course, we're not trying to hold up the spill, but then it's important that the interpretation adopted by your staff is consistent. Now, I think Mr. Vincent Fang was not trying to argue for the sake of arguing. In fact, he was referring to cashews, candies individually wrapped, and you really can't carry them in your hands, and usually when people buy these food items, they get a small plastic bag. As you are providing for so many exemptions, you might as well exempt this this case. Of course, we're not talking about giving people a very, very big bag for just a few cashews. Now, I think this bill and the amendments are challenging to members as well. We want to minimize the nuisance caused to members of the public when we try to promote environmental protection. So we should I don't think the Bill of Rights ordinance should be used when we are merely discussing environmental protection matters. Mr. Wu. And when we do not want to cause too much trouble to hawkers, to SMEs. And that is why I want to strengthen and consolidate the behavior of the public. Now, I've prepared my CSAs, and I've heard the administration's response, and I will be consulting the legal advisor further on my CSAs. Now, the administration is of the view that my amendment is not to be supported. But I think you need to bear in mind problems and difficulties that may be faced by hawkers and SMEs. You may accuse me of proposing differential treatment, but I think we can target, so to speak, the major retail chains. I think we are of the view that shops in big shopping malls, shops in MTR stations are fully capable of putting in place IT systems to provide records. I have never had in mind 3 newspaper stores operated by the grandfather, the father, and the son, respectively. And we understand that as an honor system that you are proposing. And I'm just hoping that in the process, retail groups which have the ability can help provide the records for our reference. Mr. Wu, in fact, the administration is trying to let these the small operators off, so to speak. I don't think the administration is trying to think of weird examples to show members that a dual system doesn't work. Now, I'm interested in the legal arguments put forward under the BORO. Now, I understand that the administration has looked at a dual system from 2 perspectives, the legal perspective and the policy perspective. And Mr. Lai has told us the measures that the department has contemplated, and I hope that there can be more such policy measures, and then Mr. Wu can decide whether to press ahead with his amendments. And then the legal arguments. I think the administration is trying to explain to us the issue of personal status, but then an individual or a person is different from a legal person. So how should other status be interpreted? We're told that recent court cases have shown that the line has not been clearly drawn. But if you look at the European Convention on the Protection of Human Rights and Personal Freedom, it is about anti-discrimination, in other words, discrimination on the ground of sex, race, and so on and so forth. And then there are personal characteristics listed. For example, sexual orientation, in fact, concerning these 2 cases, in particular, the latter one is about whether a prisoner should be put on parole And so that case was about personal freedom. And as Ms. Sit-ho and other members have pointed out, is it really necessary to deal with the concept of a dual system going to such a high level? Because we're only talking about large-scale companies, small-scale companies. Is it that we should look at this issue from the human rights perspective? Because many government policies do provide for differential treatment, but it is not always necessary to go to the level of human rights. So, to respond to what Mr. Lai has said, he said the discussion was abstract, and so the response was also abstract. But then I personally feel that it's not appropriate to approach the matter from a human rights perspective. Is it really necessary to invoke upon the human rights angle, the basic law, the BORO, to look at the dual system? I think we should be dealing with the matter from a policy issue instead of from a human rights anti-discrimination perspective. So I just want to put this on record. Mr. Lai? Yes, Chairman, I thank you for your conclusion. I think very often when we should be discussing human rights, we do not proceed from the human rights perspective. But here, human rights come in out of nowhere. And so I think the administration should withdraw the legal arguments in order to avoid further complicating the issue. But then that these responses have been provided. No, but sometimes if a member doesn't observe the rules of procedure, the chairman will ask him or her to withdraw the remark. And here I think we should state our consensus that the administration should withdraw the legal arguments. And you can see that Mr. Lai and his colleagues have already budged, so to speak. I don't understand the civil servants have their rules. They do not withdraw what they've said easily. But I just want to say that it's really not appropriate to bring in the human rights perspective here.
The EPD or DOJ are responding in a professional manner. So the background of this paper was that the members might propose a CSA, that is a dual-track system, or a remittance system, and we have just conducted a comprehensive assessment. Ultimately, this was just a response to a hypothetical question. If you don't need to deal with a hypothetical question, then we don't need to continue the discussion. I just want you to understand, why did we have such why did we drag this discussion into a constitutional discussion? Well, it was just a discussion on a abstract concept. Well, are we playing a game of chicken here? See who wants to swerve first to avoid the other party. So I've written down the document number where they first cited human rights discrimination. I think it's very confusing. The future law students, if they refer to our bills committee, it is very confusing. I feel Mr. Lai has informally withdrawn the argument, but the bills committee members feel that this argument doesn't hold. Now, that's our view. The government doesn't need to respond. The preparation of this document was in light of observation of the legal advisor on our previous documents. You can see in paragraph 6 we had pointed out that our understanding of other status is not conclusive, especially the court case that we quoted in the annex. It has a wider scope of interpretation. So our stance has been the justification test, and there are two ways of looking at it. We could see whether different treatment is legal. That is the test that we applied. Now, the legislators have also used this test to see whether it's an appropriate framework. So the discussion has helped us understand the legislation. The government's opinion is that since other status it's still a gray area in the Hong Kong courts, we should therefore adopt a stricter approach. So I hope legislators can understand our background. It's 6:20. We don't have a lot of time. If we don't have further questions on the government documents, then we should have entered the CSA, clause by clause examination. Can we only have some 10 minutes, can we conduct CSA, clause by clause? Chairman, we're now at the amendments of amendment stage, and we have Mr. Wu Jiwai's amendment. We need time to digest it. I understand that the Wu Jiwai needs to discuss with the legal advisor. So should we ask Mr. Wu to explain his stance, and we can study his amendment, whether it is Mr. Wu or the government's amendment? Well, I have a bolder suggestion. We don't have a large attendance. I'm afraid Mr. Wu might have to repeat himself, and I respect your submission. I also think we need time to digest the material. The policy goal is also very clear. We want a good monitoring system. So I hope that we have more time for discussion of details and the amendments. So I boldly suggest that we conclude now, unless Mr. Lai opposes. Yes, I support your decision. Well, actually, we provided a document on the last occasion. There are 4 government CSAs. I'm not suggesting that we go through those. We can save that for the next occasion. But there are 3 areas where you can deliberate. For example, the fixed penalty of $2,000. The second area is one amendment relating to taking a two-step legislative procedure being a one-step procedure. After the principal legislation, we also need regulations of commencement date, penalties, we would rather have that included in the amendments. We feel those are simpler arrangements. If they could be included in the amendment, that could simplify and expedite the process, unless you prefer a separate arrangement. And the third area is commencement date. On the last occasion, we expressed the view that we have a lot of publicity work to do, and it would take 12 months after commencement date that would be our goal. So I would like you to understand that our amendments would include these three areas. So in our next meeting, aside from looking at the clauses, could you agree with our overall direction? These three questions have been raised on the last occasion. We are responding to the government responses, and I can't provide an accurate response to your three questions because we would be dealing with the schedules and the CSAs. We might have a clear direction at that time. If members feel that no, they should handle it separately, Mr. Lai, I cannot give you a definite yes or no answer. So allow us some time to provide our legal advisor to provide legal opinion. I'd like some information to be provided on the transitional provisions. There are dates mentioned, and how does that relate to commencement date? If you refer to the document 143/1213, how are the dates calculated? It's just stated very simply. So if we just write draft bracket dates, could the administration provide further information? That is, the dates in the different provisional arrangements. What is the relationship with the commencement date? How do they calculate that? Then it would facilitate our reading. Thank you for the observation. We can provide that information. Our principle is that before commencement date, if there's a deadline, the reports, levies of the large retailers, they have to use that as a deadline for the levies and reports. We can provide information later. Just says date. Could you, if you clarify that, it would be better. One of our suggestions is that we, after concentrating the legislative process our colleagues have already given a specified date. For example, we mentioned that it takes 12 months after commencement date before we are ready. So by February, if we submit it to the council meeting, it might be 1st of March 2015. So before that and after that, how many months where the report is due or levies are due, that would be clarified. On the last occasion, we weren't sure when it would be submitted to the council meeting. So please take note, next meeting, 2014, 7th of January, 10:45. So please take note. We'll also remind members and officials we'd like to receive your documents. If there's no AOB, we conclude. Thank you very much.